Hello, I'm Attorney Dan Marr at the Nashua law firm of Hamlin and Kerrigan here in New Hampshire. I'm going to be talking about in New Hampshire how to separate yourself from a co-owner of a small business that you have. So perhaps you have a business that's a auto repair shop, a software consulting company, even a professional association like a doctor's office or the like, and you have co-owners in the company and you just don't see eye to eye. Maybe you don't think the other person is providing their fair share of the work. Maybe you don't think that they're competent in what they're doing, but you're all working in the company and you're trying to figure out how to separate yourself from there. We have obligations under the law in New Hampshire, both under statutory and contracts. If you have a corporation, you want to look at the bylaws of the corporation, the shareholder agreements if you have them, and see what type of rights and obligations are there. If you have a limited liability company, you want to, that document is called an operating agreement. You want to look at those first to see if there actually are shareholder agreements or operating agreements and bylaws if it's a corporation as well. Look at those first. That will help establish what your obligations are. One of those obligations, sometimes established right in those agreements, are what's called the indemnification obligations of the company. So if you think somebody's doing something bad, but it may not be intentional, maybe there's a carve out in the agreements that they have that they're going to be protected by the company. So if somebody else is coming after the organization and that individual for something that they did wrong, you may have indemnification obligations as the company if you're planning on being the remaining shareholder or LLC member. So you want to look at that. You also have obligations as to what you're supposed to do in regards to the arrangements. If your operating agreement doesn't have, or the shareholder agreement doesn't have a spell out on this, just thinking that these people are employees and they're employees at will under New Hampshire law, because we are an employment at will state, which means you can generally fire somebody with or without notice or with or without cause, and that person can quit with or without notice or with or without cause. That really doesn't apply unless the agreement says that between the owners as to owners of the company. When you are in a closely held company, the New Hampshire statutes, New Hampshire law, and Massachusetts law that they've utilized a lot of in New Hampshire in determining this, they determine that when you're a closely held company, one of your benefits, major benefits, is your employment. You might be the chef of a restaurant. You might be the front of the house manager of the restaurant. And that's the reason why you're a part owner, and that's a valuable part of your ownership. So the courts will look at that and not treat you just as an employee will, unless perhaps your agreement says that clearly, and then maybe you're going to be stuck with what the agreement says, but you want to see what that says specifically. And I, as an attorney, when I'm dealing with this, will look at those issues. Generally, though, you have the utmost duty of good faith and fair dealing in dealing with your fellow owners of the company. So that doesn't mean that if there's three of you, two of you can get together secretly and figure out a way to force out the other person. If you do that, you're going to be in a situation where the court's going to be looking at, well, what would have happened if you sat down with this person and had a cup of coffee or a beer with them and talked through the issues that you were having with the person. Sometimes the court or the arbitrator, if it's an arbitration provision in the agreement, may say that you should have been able to work these things out. Now, of course, things like trust, you can't cure trust. If somebody was stealing money from the company and the two of you got together and forced the other one out, you still can confront that person, but there's really no likelihood that that person is going to redeem themselves and you're going to keep that person on as a partner. So you want to talk about those issues. You want to think strategically what you can do as to forcing them to sell their shares or dissolving the company if need be. If there's two people that are 50-50 owners and both of you can say therefore no because you need a majority interest and neither of you can say yes for any decisions, then you might have a dissolution procedure. And I've done those with companies, LLCs and corporations as well. And usually they settle up before the case goes to trial. But you have those discussions and you have to talk about that. You have to talk to the other side. I've dealt with these quite a bit. You want to delve into deeply what the cause is that you're doing this. Is it an intentional act by that other person, or is it something that they could fix? Maybe they think that because they're an owner, they don't have to work as hard, and they need to have a discussion by their co-owners that they pull their own weight. those types of issues are something that you're supposed to be talking to that person, and you're not just supposed to be making a decision on your own, thinking that if I tell them, then maybe they might get up to speed and I just don't like the person anymore, so I want them out of my hair. You're going to have problems with that. I've done 36 years of litigation in this arena, both in New Hampshire and some in Massachusetts, for about 28 years in Massachusetts. And time and time again, the courts look at this and they say, you're supposed to be talking to the other side. So talk to your attorney first, get an attorney for yourself, not just the company, to decide this issue, and work through these issues. Because if you're talking to the company attorney, that company attorney has to share everything with all the members or all the shareholders. So be careful about that as well. I'm Dan Marr at 603-883-5501. I've done plenty of these and I'm happy to talk to you about these issues. You can also check out our website at NashvilleLaw.com, and you can see my weekly vlogs. And before that, I had done a weekly radio show on a variety of topics, but you can see all that on our website. But again, this is Attorney Dan Marr, and please feel free to contact me directly. When you contact the firm, if you're looking for me after the intake process, ask that it goes to me, and I'll be happy to talk to you. Again, 603-883-5501. Thank you. Bye-bye.